Some nights, some evenings, I would sit in the backyard, just have a cup of coffee and look at the stars and just get a little bit of serenity.
Angel Vera has lived in Mount Holly, New Jersey, in a neighborhood called the Gardens for over 20 years. He moved to the Gardens after he and his wife separated because it was an affordable place for him to live with his 2 children. This year, the Gardens became the epicenter of a major Supreme Court fight. The case arose from the township's plan to demolish and rebuild the Gardens, which has mostly minority residents. Earlier this year, the justices agreed to decide whether the township's redevelopment plan was banned by the Federal Fair Housing Act, despite the absence of any evidence that the township intended to discriminate against minorities. The conflict over the Gardens sprang from 2 competing views of the neighborhood. This is Jim Maley, the township's redevelopment attorney.
By far the worst neighborhood, not only in Mount Holly, but probably in Burlington County.
Maley puts the blame not on homeowners like Angel Vera, but on the design of the Gardens, which was originally built in the 1950s as housing for service members at 3 nearby military bases.
It's the way you would design a neighborhood if you were a bad guy. You would lay out really small alleys, really tight distances, make it really easy for, you to do things and not be seen.
The dense layout of the Gardens did attract drug dealing and other criminal activity. Mount Holly's police chief, Steve Martin, has been policing the Gardens since the late 1980s.
There was a lot of open-air drug markets. Drugs leads to the robbery, the assaults. We had a few homicides.
The competing view of the Gardens is that the neighborhood was a boon to low-income households because the small houses and dense lots created an opportunity for affordable homeownership.
My name is Ana Arocho, my husband Reynaldo Arocho. My house is very good. Only I pay $300 in the house.
Similarly low monthly mortgages have allowed other homeowners in the Gardens to pay off their houses. Many of the homeowners are older people, living off a fixed income, as Mrs. Arocho and her husband do. And for many of these residents, the Gardens has not been a blight, but their community. This is the residents' lead attorney, Olga Polmar.
In that neighborhood, there are a lot of people who have known each other literally for decades.
Look over here, say cheese.
I've known Norman next door for a long time. I knew Miss Brooks, the other lady that lived next door. I was really good friends. Her house is gone right now. I used to know Melina that lived down the street in the corner there, Pancho that lived over here, Angelo, Pedro.
Ultimately, the township determined that the best way to fix the problem with crime in the Gardens was to buy up the properties, mainly from delinquent landlords, and to rebuild the neighborhood from scratch. Part of the redevelopment plan involved transitioning the housing stock in the Gardens from low income to middle income by building homes that were more expensive than the ones they were tearing down. As a result, the low-income homeowners in the Gardens were effectively priced out of living in the new development. The homeowners did not see the town's plan as a way to improve their neighborhood. Here's Palmar again.
The amount that the township was going to pay for them for their homes was hardly enough for them to move anywhere other than perhaps the most depressed areas of Philadelphia or Camden or Newark. Many of them had actually moved to the Gardens, while the township was saying, oh, the Gardens is so blighted. For them, it was like kind of moving to a green, leafy suburb.
The residents sued in 2003 under the Federal Fair Housing Act, a foundational civil rights statute. The theory they sued under was that although it was not the township's intention to discriminate, because most of the residents in the Gardens are Hispanic and Black, the effect of the redevelopment plan was discrimination. After a federal appeals court ruled that the minority residents' suit could go forward, the Supreme Court agreed to hear the case. This was the second time in 3 years that the justices have granted a case on the question of whether or not minorities must prove not only that they've suffered discriminatory effects, but also that that discrimination was intentional. The earlier case settled in the wake of pressure from the civil rights community and the Obama administration, which sensed that the court's conservative majority would likely issue a ruling that discriminatory effect was not sufficient. Recently, Mount Holly settled its long-running dispute as well, and many people wondered whether the Department of Justice or the civil rights community once again stepped in to prevent the issue from reaching the justices. But the township says no.
George Saponaro, I'm the township attorney, been involved directly with the case since January 1st. We never heard a word from the DOJ or Civil Rights Committee. This was a local issue.
Richard DeFalco, deputy mayor, been involved with the case for the past 2.5 years. We ran on a campaign that was to end and settle this case, put it to rest, and begin the healing of this township.
The central feature of the settlement is that the 20 remaining homeowners who wish to stay in the gardens will get replacement homes in the new development. 7 homeowners who want to leave the gardens will sell their homes to the township and receive relocation assistance. 2 former tenants and 3 homeowners who have left the gardens were also included in the settlement, although the details of what they received are confidential. The township officials and the residents agree on how other municipalities can avoid the expense and turmoil that this litigation created in Mount Holly.
My hope is that more municipalities use a more inclusive way of redevelopment that allows for new homes, that allows for new economic growth, but that doesn't forcibly push out people from the community where they live.
My response to that is very simple. Listen to all parties, all residents, those involved, those not involved.
The question remains of how the Supreme Court will rule on the legal theory that minorities do not have to prove intentional discrimination in housing cases. The issue is likely to return to the court in 2 to 3 years.